We have now got to the one of these things is not like the other part of the day. Not a scientist, but that's okay, right? You can sit through me, I guess, before you hit to lunch. One of the things that I think is really something that it means a lot to me is the phrase that words have meaning. And as a lawyer, you're like, yeah, of course, words, whatever. But I thought it was really fascinating. I love going to conferences of people that are not my same sort of background, because people see things very differently depending on the way they view the world. And when you all came to a welfare symposium, I think it's reflected in all of the other speakers, you have an idea of what welfare means. And I think it's, at least in my perspective, sitting here listening to this, you see welfare as something that can and should be measured. That there's some sort of an experiment or an objective way to say this is a better welfare than this is a better welfare. And I think a lot of that is how you view things, what your educational background is, and sort of what your perspective on life is. Me as a lawyer, when I say, what is welfare? I say, well, welfare is whatever the definition of welfare is in this law, right? I have a very sort of granular view of it can mean different things depending on what those specific words mean. And those are just two ways of looking at it. Very objective, subjective, although I love the phrase clucks and I'm going home and telling my kids about it. But also a way of looking at it from a very, it is whatever it says it is. But we are just two types of people and two types of ways of looking at welfare. And I think the way that I fit in today is by recognizing and by sort of bringing up the idea that everybody's going to view words differently and everybody's going to view phrases and things like welfare in a different way depending on their perspective. And you're thinking, well, why is this important? We can measure welfare. We know what's important. We know if we want 5 clucks or if we want 17. But what I'm going to talk about today is a situation where everybody has a voice. And everybody has their way of implementing what they believe are best practices in agriculture, but also in other ways as well. So I'm going to talk about it in the perspective of some examples in animal welfare. But I want you to just keep an open mind, because the things that I'm talking about as a welfare perspective, or by using that word welfare, that's really just a stand-in word. It can be any kind of an agricultural practice. It can be any kind of a production method or anything other than welfare. That's just the block that we're putting in it today. So I'm talking about farming by referendum, ballot initiatives in the United States. And let me tell you a little bit about what I am and what I do first. So I'm a senior staff attorney at the National Agricultural Law Center. We're physically housed just across the driveway there, but we have a nationwide reach. And our job is to provide information and education on areas where the law impacts agriculture and vice versa. We're not a law firm. We don't represent people. We don't have clients and go to court. And what I think is the most important part of what we do is we are not an advocacy organization. Our job is not to influence policy. Our job is not to say, this is what welfare is. Our job is instead just to say, well, this is what the law says right now. This is where we're at, as of right now, how people define welfare, going back to that definition section. Okay? And this is what I'm talking about today. We're going to cover sort of 4 topics, how ballot initiatives fit into the big picture, and move down to some examples at the end. So in terms of how it fits into the picture, there are 2 different types of these laws that I'm going to talk about today. They are called popular referendum or citizen initiatives. Ballot initiatives as a whole is a situation that arises when individuals are allowed to vote on something directly rather than having their legislatures vote on it. Okay? In Arkansas, we have a ballot initiative process, and in fact, most of the states in the country do. You can, for those of you who are Arkansas voters, things like medical marijuana have been on the ballot in recent years that you may be familiar with. That is called a ballot initiative process. So there's 2 types of these ballot initiative processes. We have ones that address laws that the legislature has passed and whether those laws can stay in place. And then we have ones where the legislature has not acted, but instead, we as the citizens are voting on whether it should go into effect without any legislative involvement, or necessarily without any legislative involvement. And Arkansas actually has both of those options. Earlier this summer, you may have heard or read about the LEARNS Act and how there was a proposed ballot initiative that would challenge the enactment of the LEARNS Act in the state of Arkansas. So that would be an example of the popular referendum issue. And the citizen initiative one is where I'm going to spend the most time, because that doesn't necessarily have any involvement by the legislature. This is just a group of people who find something to be important, and then they move ahead with the process of trying to get that enacted. These happen in sort of two different ways. Once they go through the process, if they are enacted, depending on the state we're looking at, they can either be put into the constitution of the state, or they can be just put in part of the state code. In terms of animal welfare statutes, we actually have examples from both of those things. So for farm animal confinement statutes, the very first one was passed in Florida via the ballot initiative process. People voted on it directly. It passed with like 63% of the vote. Once it was passed, it became actually part of the Florida Constitution. There is a constitutional amendment in the state of Florida that says you cannot confine pregnant sows. The other option is, for example, in the state of California, when you have a ballot initiative, it goes and becomes part of the legislative code. Practically speaking, it doesn't have much effect where you put it, but it's one of those things that's just going to be different by states. I can't tell you this is how it works in every state, because every state does things just a little bit differently. But I can tell you that ballot initiatives have a very similar process from state to state, have very similar pictures, even though the details may be different. So in each state, it's typically, when we're looking at it from the citizen initiative version, we have a group of people who come up with an idea for a ballot initiative. They can prepare what they would like to see as the ballot initiative. Typically, you also have to prepare a title for the ballot initiative, and most of the time, you also have to prepare a short summary. That is then submitted to some entity within the state government, Secretary of State, wherever the agency is that's tasked with reviewing these ballot initiatives. Once they get to that point, that state agency will review it to see whether or not this is a ballot initiative that is going to be allowed on the ballot. Now, they're not looking at it for content. They are looking at it to make sure basically that its structure fits with what is allowed within that state. So a lot of times you'll see it being kicked back for things like the title needs to be changed, or the summary needs to be more distinctive, or anything that is state specific in terms of what those requirements are. Sometimes, in order to submit it to that Secretary of State or whatever that state agency, you have to have a certain number of signatures. Usually it's just a small number, maybe 1,000 or so, just to show, hey, there is some support for this. But then after the state agency kicks it back and says, yes, this is an acceptable ballot initiative, the next step is signature gathering. And each state, again, similarities and differences. Sometimes you have to gather, typically you have to gather a certain percentage of the number of voters who voted in a previous election. So maybe the last presidential election, you have to get X percentage of those voters. Sometimes there's other requirements, such as you have to get a certain percentage of voters from every county in the state, or from a certain number of counties in the state. And again, that's all going to be very specific to individual states. But we are looking at a larger number of signatures, okay? So we have the smaller number that they have to do initially, then we have this larger number of signatures that we have to do in order to submit it to be on the ballot as a whole. And then the signatures have to be turned in by the deadline. Some states have requirements. You can have paid signature gatherers. Sometimes they have to be volunteer. And again, we're looking at very specific requirements per state. After they're turned in, then they are either approved to go on the ballot or not. So we are looking at two different types of signature of citizen initiatives. We have direct initiatives, where once it qualifies, once we have that X number of signatures, once we have approved it, it goes from there directly to the ballot. The next time you see it is when you vote on it at the ballot box. And the ones that are in dark green are states that have this direct ballot initiative process. For states that we have lined here, they have, depending on the type of ballot initiative, we have options for both direct or indirect. Indirect ballot initiatives are very state dependent. The common denominator is that the legislature is involved at some point in the process, whether they have to approve the ballot initiative, whether they have a chance to make objections, or so forth. At some point in indirect states, we have the legislature involved. And the National Conference of State Legislatures has some really great resources on this. I would encourage you to utilize the QR code if you're interested. You can just aim your phone at that and it will take you right to the website that talks more about it. So we have the dark green states that are direct. We have the line states where they have an option for direct or for indirect. And then we have the light Wyoming, Maine, and so forth that have an indirect access to the ballot. And that's how ballot initiatives are set up, generally speaking. Again, very state specific, but those are sort of the big picture similarities between them. This is also something that state legislatures are very interested in right now, with a renewed interest in direct citizen action and interaction with the legislative process that we're seeing sort of broad picture. This is something that state legislators are bringing up. And so, these are the bills in the current legislative session. All of these states that are in green have current bills that would change the ballot initiative process within their state. The colors that are tan there, those states, do not currently have a ballot initiative process, but they are being proposed. Okay, so you add those to the ones that already have a ballot initiative process in place, and we have absolutely covered the vast majority of the country. Okay. So let me talk about a couple examples within animal agriculture. My research focus is on legal issues in animal agriculture, and this is actually something that I've covered since Proposition 2 in California was an important thing. It still is now, but not nearly as important or up to date as Prop 12. So California, the ballot initiative called Prop 2 that took place in 2008 was really important because it was the first farm animal confinement statute that covered laying hens, pregnant sows, and veal calves. It was the first one that made that leap to birds beyond just those other two animals. And when it did so, that was through the ballot initiative process. People voted on it, and citizens of California decided that that is something that they wanted to put into play. Within a year or so, there's actually a follow-up legislation that was not a ballot initiative. It went through the legislative process that said that if you sell eggs within the state of California, shelled eggs, so like a dozen eggs you'd buy at the store, if you sell those in the state of California, that you have to ensure that they have to come from farms that have places that are compliant with Prop 2. So no matter where those eggs were from, no matter where those birds were from, no matter where those eggs began its product life, to sell it in California, it had to come from Prop 2 conditions. So then we move ahead, and I have a whole presentation on these types of statutes. We move ahead to 2018, and in Proposition 12, California took it even further. What they did was two parts. They prohibited the act of confining farm animals within their state in manners that are considered to be a cruel manner. Now that's defined within their state actions, within their state code. But so that's part one. Part two was they applied those same standards to any product that was going to be sold within their state boundaries. Hopefully most of you have heard of this, at least ringing some bells for you. So any product that was sold within the state boundaries had to come from animals that were raised within the same living conditions that they required within the state boundaries. In other words, practically speaking, we are looking at for eggs that are either produced or sold in California, they have to come from cage-free birds. This is an extension of what Prop 2 required. And then secondarily, for pork or for veal that is sold in California must come from farms that do not use veal crates or gestation crates. Okay, so we are again looking at sort of two parts. We have the production and we have the sale. And that second part, the sale, is where things became a little bit more iffy. Okay, and so there was actually a lawsuit that was brought against Prop 12. It was brought by National Pork Producers Council and American Farm Bureau Federation. And they said, we have no problems with you passing a law that says what producers in your state can do, because that's the role of state government. But they argued that in order to pass a law that affects the entire country in the way that Prop 12 did, you can't be a state government. You have to be Congress. And so they took this to the district court in California, who dismissed it immediately. They took it to the Ninth Circuit, dismissed it immediately, and they appealed it to the Supreme Court of the United States. And I mean, I don't know, I don't want to say nobody thought that the Supreme Court would take this case. I didn't think the Supreme Court would take this case, but they did. It was heard last October. At the Supreme Court, they talked about how and where cows should live in the state of California and anybody who wanted to sell stuff within the state. And so when they heard that, they had three different options, three different possible results. They could say, yeah, California, you can do that. It's fine. Prop 12 goes into effect as scheduled, and states have the ability to do so. Secondarily, the effects would be that other states can do something similar, can pass similar laws that have similar effects to production methods outside of their area. They could have sent it back. They could have said, we don't have enough information to make this decision, and so we're going to send it back to the trial court, and they can have hearings, they can have briefings, and they can have more information to find out if it is or is not constitutional. The other option was they could say, California, you can't do this, and that would strike down the law. It would be unconstitutional. In which case, Prop 12 would still be in effect, at least for that, Prop 2 would still be in effect, but Prop 12 would not, at least the provisions that apply extraterritorially outside of the state. And the Supreme Court chose option number one. They said that Prop 12 is constitutional and it's enforceable by the state of California. In terms of things that you may not find interesting, but I thought were so, as a lawyer looking at it, this was what's called a split decision. It wasn't a decision where everybody agreed. And even in the places that everybody agreed on the result, AKA that it's constitutional, they didn't agree on why it's constitutional. So there's like A, B, C, D, E, F, G sections of this ruling, and every one of them at the very beginning of the section says, this section is joined by A, B, and C justice, and the next section is, this section is joined by 1, 2, and 3 justice. And every single justice went through and decided what sections or what reasoning they agree with and what they don't. There's also 4 or 5 concurrences and dissents. Fun stuff, great reading, 50 pages of wonderful, joyous stuff. If you want to read it, there's a QR code. If you want the 2-page summary, there's a QR code for that as well. All right. So I'm not going to go through the analysis. I don't think I have the time. I'm happy to talk law with you anytime you'd like. However, but let's move on to what effects it had. So as of right now in California, the regulations for veal calves and for laying hens currently effective. At this moment, you as the producer and you as the retailer are allowed to self-certify compliance. You can submit the paper that says we are doing what we're supposed to. California, we're not violating your law. As of January of next year, it has to be third-party certification. So for PACO folks, this is going to be important to you because that third-party certification is going to come from a third party. For pork, based on a ruling in a separate case, it's a little bit more complicated. As of right now, if you're a producer in California, you have to have compliant housing. End of story. For sales of goods, for whole pork meat that is sold in California in this year, it depends on when it was processed. If it was processed before July 1st, then these rules didn't apply to it. Non-compliant pork is okay. It can be sold up until the end of this year. If it has been processed since or after July 1st, then it has to be compliant. Non-compliant pork can only be sold until the end of the year. Since July 1st, it has to be compliant. At this point in time, compliance can be self-certified, although just like for eggs and for veal, beginning 2024, it has to be third-party certified. I think it's important to note, though, that while these regulations are in effect, the Department of Agriculture for California has said that their goal for the next, until the end of the year, is not going to be on enforcement, it's going to be on education. And so they're not actively going out and looking for people who are not following the rules. They are instead waiting to see if it is they are instead waiting to see if there are any complaints. And so it's going to be education unless there are complaints, in which case they will investigate. But California isn't the only state where this is relevant. There's another ballot initiative on the other side of the country. Massachusetts in 2016 had what they called Question 3, and it did something very similar. But you don't hear as much about Massachusetts because they don't have really the landmass, they don't have the citizens, they don't have the market share that California does. But what they do have is they're a very small state on the eastern seaboard with other small states around it. And so regionally speaking, they do have a very large impact, especially if, as I've heard from several places, buyers in the state of Massachusetts or that region are requiring that all meat, even if it's not intended for Massachusetts, go to the highest common denominator and meet those Massachusetts standards. So whether it's sent to Massachusetts or whether it's sent to Rhode Island or any other states around there, it meets those Massachusetts standards, which expands the market share dramatically. So as of right now, Massachusetts Question 3 is currently in effect for all relevant products, egg, veal, and pork. There we go. In July of this year, however, there was a lawsuit that was filed challenging Question 3 and making many of the same arguments that the Prop 12 claimants did. So the Supreme Court decided it based on Dormant Commerce Clause grounds. And I told you that there was a lot of dissents and concurrences that were written. One of the dissents was written by Justice Kavanaugh. And in his dissent, he said, "This is what I think." And then he outlined half a dozen other reasons that he also thinks that California may not be able to do this, and said, "I would have liked to hear about all of these reasons why this is unconstitutional." We didn't hear about them, but something I think might have been an issue. Obviously, somebody was paying attention because in the Massachusetts case, all of the potential grounds that Justice Kavanaugh identified as having been unconstitutional are listed in there as other reasons that it may be unconstitutional. I looked earlier this week, and we have some deadlines coming up in this case. It seems that the judge has taken a pretty active stance in resolving this case very quickly. So as of this week, this is what we're looking at. They're setting a hearing as of Monday, October 2nd, and we'll see where it goes from there. But as of right now, this is pending, and we'll see if this has any effect or if it's dismissed, because the Supreme Court really just answered this question 5 months ago. One other thing that Justice Kavanaugh said, and the reason that I think that this topic is so important, is because while welfare, and specifically in this case, farm animal confinement, is sort of the phrase of the day, this is like a Lego, right, guys? You can pull out farm animal confinement and you can put anything else. And Justice Kavanaugh mentioned that in his dissent. He said that if this is upheld against all constitutional challenges, California's novel and far-reaching regulations could provide a blueprint for other states. That other states can pull out that Lego of farm animal confinement and put whatever they want in there. And then you end up with corporations or companies or producers being forced to follow a different standard in every state where they want to sell products. So after thinking about it like this, I spent 5 minutes. I said, I'm challenge myself to spend 5 minutes coming up with different ways that you can see this in effect potentially in agriculture. And obviously I started with animal welfare. You could have a state that says you can only have the sale of grass-fed beef. A state that the sale of only dairy that comes from cows that have not had tail docking. We're going to talk about this potential Colorado ballot proposal that would have very significant changes. Environmental issues, only from states that do or do not use certain pesticides. We have states that are outlawing certain types of pesticides and the usage of them, other states that are limiting specific ones significantly. What if they expand that to not only producers within their state, but also people that are selling within their state? What about energy? When the Supreme Court said that this is something that states can do, that states can pass laws that have an outside effect on production in other states, they talked about how difficult it is to sort of weigh somebody's moral judgment about what is important in terms of welfare versus the maybe more easily quantified effects that it has on commerce or that it has on health and welfare or other things. And they specifically refused to answer the question of, well, can you make those moral judgments? They're allowing them to make these moral judgments. So we're not just looking at California. I know a lot of people say, well, it's just California. But we're also looking at states that may have a completely other perspective. So here's a good example. We could have one state say we can only sell products that come from companies with so much carbon neutral footprint. We could have oil and gas companies that say the opposite, oil and gas producing states that say the opposite, that only come from companies that have so many fossil fuel uses. Or something like labor. We could see these types of statutes that apply to many different types of agricultural production, but have effects, not necessarily state by state, but when you look at it as a different requirement or a different footprint in every state in the country, that's where I think that this ruling could have the most significant impact. So this is actually a slide that I pulled from the very first Yvonne Thaxton's symposium way back when that I did on Prop 2. And so this is a slide I pulled from that for this. And I know it's sort of silly, sort of dated, but what I want you to look at is this third row here, where it says how it was passed, and then watch the movement. Things start as a ballot initiative because it's easier to sometimes convince people that are individuals rather than to convince people in the legislature to make major choices, major changes. And so it starts as a ballot initiative, and as it moves through the process, we have a ballot initiative, then we add another ballot and add another animal at the second ballot initiative. Then it becomes legislative, but it takes a step back, but it's really big because it's the first time that a legislature has passed it. And you can sort of see that evolution as the rock is rolling down the hill and these changes are being made. It's always hardest to be the first one in line. It's always easier after that. So here's another couple examples in the farm animal welfare of ballot proposals that have taken place within the past year or so. This one is from 2021, and it happened in Colorado, and it is not currently active. I think it's really important to say that because when I put this up here, you're all going to be like, oh my gosh, I can't believe this is a possibility. This is not something that they are currently voting on. In 2021, there's a very real chance that they could have. It would have prohibited the slaughter of livestock within the state unless the animal had lived 1/4 of their natural lifespan. For those of you in production, right now you're looking at your animals and thinking, I'm not sure the natural lifespan that they believe is the natural lifespan I believe. There is an example of why definitions matter, because this is what the definition is of a natural lifespan. So if this had been put into place, that's what natural lifespan is, regardless of what evidence or information you guys had in your research. And the second part of this ballot proposal would have redefined bestiality provisions in a way that would have eliminated many of the farm animal production methods that we use in the United States today. I have some examples here of things that would be eliminated or allowed under that provision. So remember how I said that different statutes in different states have different requirements. In Colorado, they have a requirement that each ballot initiative can only be on one subject or one topic. And the Supreme Court said that this is not a single subject, that slaughter and bestiality provisions are separate enough that they are two separate subjects. So as is, it could not be a ballot proposal. So as of right now, this is not in effect. It's not being considered or so forth. That's not to say that if I were to come back in a year, we wouldn't say something different. All right. This one, however, is currently working its way through the process on whether it becomes active, and it's in Oregon. Another ballot proposal will be voted on by Oregon voters, and what it will do is it will remove most exemptions to animal cruelty laws, including things for good husbandry practices, transport, slaughter, fishing, hunting, trapping, research, and rodeo. And so under that, we have the animal cruelty laws that say if you mistreat an animal, it's a criminal offense. And then it has specific things exempted, such as those exemptions right here. So by removing those exemptions, it would move things like slaughter back into the animal cruelty realm. Okay, so it would significantly impact or eliminate the use of animal agriculture in general in this state. Additionally, it would expand the bestiality provisions in a similar way to what Colorado would have done. Again, there's some ideas of what it would have done in practice, but it would have had, I think, objectively speaking, a very significant impact on agriculture in the state. As of yesterday, when I looked it up, it has been approved for circulation. So the people who are sponsoring this, the people who are behind this proposal, they have to get over 100,000 signatures before it can appear on the ballot. So that's where it's at. Whether or not it makes it, obviously 100,000 signatures is a pretty high bar. Whether or not it makes it is not for me to say right now, but it is something to think about. This is a ballot initiative. This has not gone through the legislature. This is an example of that chart that I put on the board where 3/4 of the states were colored green. In 3/4 of the states, there is the ability for ballot initiatives, whatever they say, to be voted on directly by people who have an interest and for people who are educated by the proponents and the opponents of this ballot initiative. I will say that there is a proposal in Congress that was directly in response to what happened with the Supreme Court case. It's called the EATS Act, or Ending Agricultural Trade Suppression. And what it would say is that state governments cannot impose standards or conditions on the pre-harvest production of products that were raised in a different state. So if, for California example, if it was raised in Florida that has a requirement that you can't have gestation crates, then you would have to go by Florida standards. If it was raised in Iowa that doesn't have a requirement, then there would be no requirement. So whatever that state requirement is would sort of be the floor. It's very questionable whether that's going to go anywhere. There have been letters signed opposing the EATS Act, bipartisan letters by a large number of reps and senators that have been given to both USDA and the House and Senate Ag committees. As well, Harvard Animal Law and Policy Program has done a legislative analysis saying that if this were passed, that it would have significant effects outside of just affecting Prop 12. It would affect laws dealing with zoonotic diseases, plant and pest type laws, food safety and natural resources, and so forth. If you're interested in reading that, there's a QR code for that as well. And finally, here's my contact information. If there's a question that you don't have a chance to ask today, or if you just have something else you want to talk to about ag and food law generally, or animal ag, legal issues in animal ag more specifically, I'm happy to talk with you about it. Feel free to take a picture of this. That way you have my contact information moving forward. The QR code on this slide is for a resource that we have created called the feed. So every 2 weeks, we send out the feed that has sort of a brief update, short blurbs, couple sentences on events that happened in the ag and food law arena within the previous 2 weeks. I encourage you to sign up for it, and happy to take any questions that we have time for. And again, I think we have a discussion after lunch as well that I'll be here for too. This is where all the scientists are like,
There's some pretty serious stuff. No question?
Thank you, Elizabeth. That was good. So like I think it was Oregon, maybe where they were talking about changing the rules around something that could impact artificial insemination.
Mhm.
So would like the turkey producers be saying, hey, basically you can't sell any turkey products in Oregon if this pushes through, or are they
No, as
being
written,
aggressive, or
that Oregon proposal would only apply to production within the state.
Okay.
But that could very easily go one step further, which is exactly what happened in California, where it applied not only to production, but also to the sale of products.
Yeah, but that would be a likely next step though, right?
That could be a next step. But that's not in the current proposal, no.
Okay, all right, fair enough.
Hi. So for the livestock lifespan or the lifespan, who came up with that definition? Is that just
The group that is sponsoring that proposal. And that's when I said at the beginning, it's whatever the definition says. That's, I think, a really great example of that, in that it doesn't necessarily have a scientific or a foundational background to it. It's just what the definition says, and whatever the definition says is what it's going to be.
Thank you very much. I have many questions. I'll just ask one and save the rest for after lunch. Just out of curiosity, I think it was with EATS, there needed to be 100,000 signatures to go to the next phase, which
Nope. So the EATS Act is a proposal in Congress. So the members of Congress will be voting on whether or not that is enacted. The ballot proposals are the ones that people vote on directly. And each state has a certain number of signatures that must be gathered before a ballot proposal makes it.
okay, so that number varies by state.
Absolutely, it does.
Okay. Do you know
A lot
what
of
it's based
times,
on?
it's based on the percentage of either registered voters or the percentage of people who voted in the last election.
Well, at least it's on the number of voters that are more likely to vote.
So, for Nebraska or North Dakota, it would be different than New York or California.
Although then again, there's some comments that could be made about the availability of voting and the number of people that are actually registered to vote and things like that. But okay, does anyone else have a question before lunch? Again, we'll have a round table. All right, let's thank Beth Rumley.